My name is Porrick Hughes. I'm the legal director at Media Defence. For those of you who don't know Media Defence, we're essentially an organization that supports journalists who are facing legal threats all around the world. And we do that through supporting their lawyers by funding them and by taking strategic litigation cases to courts around the world at domestic level and also internationally. Today, the session is about international legal standards. And we've brought together both the Asia and the MENA region for this session, partly out of convenience, partly because there are commonalities between the lack of an international mechanism to access, in contrast with, for example, Europe, where you have the European Court of Human Rights, and Africa, where you have a range of regional courts which are available and which are quite active in relation to freedom of expression issues. I want to give an overview of the general kind of legal framework or legal landscape that exists and which is quite similar across different regions and across different states. That's one of the benefits of international law and freedom of expression. There are very few differences. When you get down to granular details on some of the issues that arise and some of the issues that are increasingly arising in the context of digital rights, for example, you will find different approaches to issues like the right to be forgotten, for example, or SLAPP suits. But in broad terms, you have specific legal standards that are contained within international instruments and legal instruments. But just to highlight a couple of the challenges that exist for journalists generally and specifically for cartoonists, these are the kinds of issues that I'm just going to be referencing as we move along over the next 40 minutes or so. You'll see them there on the first slide. Satire is a form of expression. It's not necessarily something which is ever directly criminalized through legislation, but it's important, I think, to know how the courts approach the question of satire, because it has been something that's come up in different contexts, certainly at the European Court of Human Rights, for example, and in other circumstances, in other regions. It has been something which courts have had to grapple with the meaning. So we'll just briefly touch on satire, and then we'll look at the kinds of legal threats that cartoonists are facing. I won't go into any great detail on these, but I'll just touch on some of the common ones, and then the ones that are emerging in the context of changes in technology and advancements in technology and so on. But you have your common specific issues around defamation, sedition, copyright issues, and so on. And then you've got new challenges that are arising in different jurisdictions. We see, for example, data protection slowly overtaking defamation as a cause of action, or potentially privacy arising in the context of statements around, for example, private figures which would replace the old defamation proceedings, simply because it's easier to bring those cases home, whereas defamation is very well established and provides specific defenses which media houses and journalists can utilize. So that's the kind of broad overview of the challenges that are being faced by cartoonists, not just in the Asian and MENA regions, but all over the world. The reason I raise it, and the reason we're talking about these general standards on freedom of expression, is because it's important to remember, and we come across this all the time, wherever we are, either representing journalists who are facing legal threats or supporting lawyers who are representing journalists facing legal threats. You can and should, you must rely on international legal standards when it comes to freedom of expression. And you can look outside, for example, your own country, to other countries, to other regions, to other international courts who have been very explicit in setting down the standards that should be applied in the context of freedom of expression versus, for example, the right to privacy or the right to reputation or any of those other challenges that will be brought in the context of a cartoon that purports to insult an individual. So this is why we're looking at the international landscape, but the domestic landscape will obviously have its own specificities within which the international standards should apply. So those are the challenges, the kinds of issues that arise for journalists. And this is the legal landscape. Now, in the context of Asia and the MENA region, you don't have the benefit, quite of the benefit of, for example, the Inter-American system or the African system, where you have the African Charter on Human and People's Rights, for example. But in addition, in Africa, you have other standards that journalists and media houses and cartoonists are able to rely on. Now, I say that in the context of MENA. Obviously, in North Africa, you have the African Charter applying to most countries. I think all countries now, I think up until recently, Morocco hadn't signed up to the African Charter. I think that's changed recently. So in the North African context, you do have the African Charter that you can rely on. At the European level, we have the European Convention on Human Rights. And what these do is they are essentially regional constitutions, and they state the position in relation to the protection that should be provided to journalists and media houses and cartoonists in the context of their work. And they're all very similar. So for example, the UDHR, the Universal Declaration on Human Rights, that makes various statements on freedom of expression. That doesn't really have any teeth, any legal standing, if you like. But what it does do is it provides the baseline, or the underpinning from which all of the other regional and international covenants and treaties come. So post UDHR 1948, you have the ICCPR, and you have the International Covenant on Economic and Social Rights as well. Both UN instruments. Article 19 of the ICCPR is the relevant article. And you have to remember, in relation to the right to freedom of expression, that it is not an absolute right. So for example, the prohibition on torture is an absolute prohibition, if you like. The prohibition on slavery is an absolute prohibition. But the right to freedom of expression is not absolute. There are restrictions. And it's those restrictions which have given rise to all of what I would consider the very interesting case law, the way in which the courts balance out the right to freedom of expression versus other rights. But in the Asian and the MENA context, the ICCPR applies, and the International Covenant on Economic, Social and Cultural Rights applies also, often directly. But that's not to say that you can't rely on what European courts have said, what inter-American courts have said, what African courts have been quite vocal about recently in relation to the right to freedom of expression. You're essentially looking to rely on international and comparative standards to give weight to your argument that under the ICCPR, for example, where it applies, your right to freedom of expression has been violated. Now, as I say, there are commonalities across regions in relation to the way in which these standards are applied. And the fact that this isn't an absolute right, there are restrictions, is well understood by courts, and the courts have a framework within which they work to allow them to understand better whether or not the right to freedom of expression has been violated, where for example, a cartoonist's work has been censored. It's a fascinating area in the context of freedom of expression, because it's just slightly outside, it's slightly left field in terms of how you interpret what is being presented. Because oftentimes in the context of defamation cases, for example, the question of meaning is the key question that needs to be understood by all the parties before they even get into the argument about whether or not a person's reputation has been affected in a way that entitles them to damages, which is the essential definition of defamation. But in the context of cartoons, that's a difficult question to answer, and judges do find it difficult to understand precisely how they should approach the question of whether or not a cartoon violates somebody's right to privacy or is defamatory in its content, because context is everything. Cultural mores are important. Different aspects to a society where this cartoon is being presented to will impact on whether or not a judge considers. Now, that's assuming you're talking about an independent, non-biased judge who's going to give you a fair hearing and who's going to apply the international standards. The question of whether the cartoon is or is not an infringement of someone else's rights is a difficult question, often, given the content, if I can call it that, of the cartoon and the different and varied ways in which interpretation can be applied to a cartoon. But you do have all courts do or should, because this is essentially international law, so they do or they should apply what they call the three-part test. And the three-part test is really very well developed in the way in which it's been applied to different contexts and different situations. The three-part test essentially states the limitation must be provided for in law. That doesn't necessarily mean it's simply a question of a piece of legislation which allows, for example, a government to censor a cartoon. The legislation or the law must have what they call the quality of law. It can't be an arbitrary application based on the whim of, you know, somebody who's in charge of a particular state or someone who's in a powerful position in a particular state. It must have the quality of law, and that's a legal question that's often explored in the context of challenges to censorship issues, for example. The limitation or the restriction must pursue a legitimate aim. That's the second part of the test, or the second limb of the three-part test, as we call it. Now, pursuing a legitimate aim is a difficult question. It's something we as litigators often avoid addressing until we hear what the government has to say, because we can't simply say, well, there was no legitimate aim. We'll say, we don't think there's a legitimate aim, but let's wait and see what the government says. But it is the third limb of restriction, which is the most interesting and the most well-developed in terms of its case law, or the most argued in terms of the way in which it applies to a particular situation. And that is, it must be necessary for a legitimate purpose. Now, the third limb is phrased in varied and different ways. Essentially, it must pursue a legitimate aim and be necessary and proportionate is another way of putting it. It must be necessary and proportionate. And then you get into whether or not, for example, the use of criminal law against a cartoonist is necessary and proportionate, necessary in a democratic society and proportionate to the aim sought to be achieved, whether there is another way or another measure which could be used, which is less restrictive in terms of the rights of the individual who's being affected, for example, whose cartoon is being censored. But the third limb is the most interesting, and it gives rise to the most fraught, most controversial kind of argumentation before various courts, because in as much as the case law is very well developed and the standards are well developed, there are areas of law in relation to international freedom of expression standards which are not well settled, and there are legitimate arguments on both sides as to whether or not a particular position should be taken. But that's just an overview of the restrictions the test which a government must meet. And remember, it's a cumulative test. It's a test where if the government falls down on even one of the three tests, then they have failed to comply with international legal standards on the right to freedom of expression. They have failed to comply, for example, with Article 19 of the ICCPR, depending on the context. In terms of satire, as I mentioned, satire, cartoonists, the way in which cartoonists operate, I mean, it depends on the context. It depends on the social mores, the cultural mores, political norms, the political situation at that moment, and so on. But the European Court has been very strong in terms of providing protection to cartoonists who engage in satire. The standard that they use, or the phrase that they use on a regular basis, is that freedom of expression in the European context allows somebody to shock, offend, and disturb. This is the phrase, and this is a similar phrase. We'll come to it in a moment. It's used across various international and regional courts to offend, shock, and disturb. And the European Court has given a definition, which is, I think, quite useful. And remember, if you're in the context of defending a case in a specific country in Southeast Asia, for example, we do have these debates when we litigate these cases, whether or not a judge would appreciate hearing from a lawyer on international standards from other regions or other jurisdictions, and whether they would be useful. If there is that kind of approach where they're receptive to arguments from outside their jurisdiction, I do think it's helpful to rely on case law where the law is quite well developed on this area. So, for example, in the context of the European Court, you do have a specific approach to satire and a definition of how satire should be considered. So, on the next slide, in relation to legal standards dealing with satire, in a way, the high-level courts have essentially set out the specific standards and the specific approach that should be taken in relation. Satire is a very difficult thing to measure. It's quite amorphous. It's difficult to define. So there's a high margin of appreciation in the way in which courts will approach specific issues relating to satire, but it comes up from time to time in the context of cases at the European Court of Human Rights. I know it comes up in the context of people being arrested. We look at some of those cases in certain countries in Asia and the MENA region. You do have an approach which has been endorsed by the UN Special Rapporteurs, and I would urge you also to bear in mind that the UN Special Rapporteurs on freedom of expression, for example, on protection of human rights defenders, have been very active also in relation to speaking up for cartoonists, for emphasizing the international standards that should apply. There was a recent case in relation to Bangladesh, for example, where the new UN Special Rapporteur on freedom of expression issued a very strong statement calling for the release of a Bangladesh cartoonist, Kishore, I think was the name. So there are legal standards out there which you can turn to when you're dealing with censorship in the context of cartoons. Hustler magazine and Larry Flynt versus Jerry Falwell. Now, for those of you who don't know, Falwell was a very famous religious preacher. Hustler magazine is an adult magazine. Larry Flynt is its publisher. I'm not sure if he's alive or not. There was a famous movie about him a number of years ago. I don't think in relation to this case, in relation to a very similar First Amendment case. First Amendment is the US equivalent of Article 19 of the ICCPR. In this case, this is not a cartoon. This is essential, but it is essentially satire. And it is a kind of a parody, if you like, of a very well-known ad about a drink called Campari. Now, in this case, Falwell sued the magazine and the owner of the magazine on the basis that he had been defamed because he was a religious person, and this ad made a certain references to his alcoholism and other vices. He sued on the basis he had been defamed, his privacy was breached, and there was an intentional infliction of emotional distress. It's a specific, what they call tort in US law. So 3 aspects to the case. It went all the way to the US Supreme Court. And it's interesting because of the way in which the court considered the content of the ad, or the content of the parody, I should say, because at the very end, you don't see it because it's in small writing, but it does say this is a parody, essentially. So it's making clear what it is. But the court considered this in the context of Jerry Falwell's reputation and position as a person in the public eye. He was a public figure. Now, there is a standard in international law relating to criticism of public figures. The general approach is that public figures, those in the public eye, are meant to have a thicker skin than private individuals. So criticism of them is more acceptable in the eyes of the court than criticism of a private individual. That is a standard. It used to be the opposite. It used to be the case that individuals in the public eye were more protected than private individuals. That changed. There have been a lot of changes in relation to the approach of media houses and journalists and cartoonists to powerful individuals. I mean, you have the famous case of Sullivan versus the New York Times, which is referenced in this this Jerry Falwell case, which reduced the ability of the U.S. Of plaintiffs or complainants in U.S. cases to sue in defamation. That's now under threat, by the way. There's a big case going to the U.S. Supreme Court where they're seeking to reverse the case of Sullivan versus the New York Times, where the US court essentially said it's okay to make mistakes when you're reporting as long as those mistakes are not intentional and malicious, or words to that effect. I'm paraphrasing, but essentially that was the approach, because otherwise the risk for media houses and journalists would be too high. The chilling effect would be too great. So you do have these standards arising out of Sullivan versus the New York Times, which is referenced in this case. And the court's position here was, well, it's clearly a parody. It's a parody of a famous individual. And to prevent or to find in favor of that individual against this, this magazine and this publisher would have a chilling effect that would be too great, and the impact on the First Amendment would be too great. So they decided in this case that actually the case that was brought by Falwell should fail on all three grounds. Defamation is an interesting one, because in some jurisdictions, certainly in the UK, you can see a reduction in the number of defamation cases that are being taken against journalists and against media houses. Instead, you have cases being brought in the context of the GDPR, data protection cases, privacy cases, because the threshold to bring those cases home, to succeed in those cases, is not as high in comparison to a defamation case, where you have a range of different defenses which have been the subject of considerable judicial comment and are highly well developed. Having said that, for example, the UK, and I've just used the UK in the context of how these things develop over time, the UK is considered to be the home of defamation. If you're a person in a position of power, you go to London to sue. Whereas in the US, there's a completely different approach. In the US, Sullivan versus the New York Times, which, as I say, there's an effort to overturn that case coming up very soon, or at least reduce its impact, states that essentially people in positions of power shouldn't, they're not really able to sue unless the journalists or media house engaged in a specific type of behavior. But defamation is the issue here. Criminal defamation is something which special rapporteurs have been really quite critical of for a considerable period of time, especially if it's accompanied by a prison sentence. Criminal defamation has a significant chilling effect. There have been efforts to remove it from the legislation books in various countries. The problem is, we've seen this, maybe some of you have an understanding or appreciation of how this has played out in your state, where criminal defamation has been removed from the legislative books, but it's been replaced by very high damages awards in civil defamation claims. So you go from having a fine, maybe a prison sentence wouldn't necessarily be something that would be handed down as a matter of course, but you would go from a small fine but a criminal record to a very large award of damages, including often punitive damages and the shuttering of a media house. And we've seen that play out in different jurisdictions. But defamation essentially is the diminution or reduction of someone's reputation in the eyes of right-thinking people generally. That's the kind of definition in the common law that's been relied on by courts for very many years. And then again, I use the example of the UK, but they introduced the Defamation Act in 2013, and that's kind of changed the way in which defamation is now dealt with at the courts in the United Kingdom, and oftentimes where the UK or the US goes, other countries can occasionally follow. But in general terms, defamation is becoming less of a threat in certain jurisdictions. Having said that, where it becomes a live threat in the context of cartoonists, it's important, and it's worth saying at this stage that you are able to access good legal advice to understand precisely what's going on in relation to your case. We just have two examples there of different jurisdictions, one in the South American region and one from Europe. If you look at the European case, for example, there is and there has been a move in Turkey to undermine and attack cartoonists, those who are engaging in visual expression. There's a famous case I was involved in at the European Court a number of years ago, where a judgment came out in relation to an art exhibition, essentially, where it was found to be offensive by the domestic courts, and the European Court said it was a form of expression, and they spoke quite eloquently about how artistic expression should be protected. It was important in the context of Article 10 not to suppress that kind of expression. The European Court is, as I say, it's a rich source for this kind of case law and this kind of jurisprudence. Data protection, it's difficult to conceive of how it arises in the context of cartoons, but we see data protection issues arising in a range of ways, and it's an evolving area because the GDPR has come in, because lawyers and reputation management companies understand that there is a number of tools available to them in different jurisdictions to rely on in order to impact on the way in which, for example, cartoonists operate. There is, for example, in the GDPR, I know it's an EU specific piece of legislation, but there is in the GDPR a reference to what's called the right to be forgotten. For example, it's codified in the regulations. Now, given the nature of the transnational nature of how websites are accessed in different jurisdictions and so on, you can face these threats all over the world. I mean, they come in the form of what we call SLAP, strategic litigation against public participation, cases that are brought purely to put pressure on you so that you will withdraw whatever you're doing. Take down your cartoon, for example. Or perhaps there's a cartoon that exists from 10 years ago, and a politician in a particular country writes to Google and requests that under the right to be forgotten rules, under GDPR, under the famous Google Spain case from the Court of Justice of the European Union, that cartoon should be removed. And that can apply even to if you're operating in Asia, if you're operating in MENA, you're still dealing with a kind of a transnational way of accessing information and accessing cartoons, and those requests can come from people who are alleging that they're affected by the information that remains online, and they want it removed. So that's something that you may not even hear about, and it's removed. And that's something that media defense is actually quite active in seeking to combat through litigation and so on. It is a difficult one. Sedition was on the legislative books of a number of jurisdictions up until only recently, and it's been removed because it's seen as being a direct contrary to fundamental first principles of the right to freedom of expression. I'm sure you're familiar with the Asim Trivedi case, the Indian cartoonist, but I will leave you to look at that. Essentially, it's where you're seeking to undermine the state. The problem with sedition is it's so broadly worded and so vague in the way in which it's worded. It can be applied, and it's often a criminal charge. It can be applied in a way which means it's very difficult to counter. And it's on that basis that you would make the argument that remember I talked about the restrictions, you would make the argument that it lacks specificity, so it's not in conformity with the law, the quality of law. If we move on to the next one, these are the Bombay sedition guidelines. These came out of a case. Now, I don't think they've been adopted or accepted. They came out of that Indian case I mentioned. I don't think they've been adopted or accepted in in India. I'm open to correction, but I do understand that there was an effort to codify them, and that was rebutted, or there was a refusal to do that. That was simply the High Court in Bombay saying that if the police are going to prosecute a case, they need to get an opinion from the prosecutor as to why something is worthy of being prosecuted as seditious. If we move on to the next thing, this is the famous Zunar, the recent Zunar cartoon. There was talk, I think, of the sedition laws being removed in Malaysia, but that didn't transpire some years ago. I think they're still on the books, and this is a consequence of it. Again, it's something that we would wholeheartedly support in terms of providing finance to lawyers and advice on how to proceed with a case like that. Hate speech is something that cartoonists should be conscious of because of the way in which it can be interpreted. Remember, I talked about the approach of various international courts that an individual is entitled to offend, shock, and disturb. The limitations that, certainly from a media defense perspective, we're always conscious of when we're taking these cases, is that there should be no incitement to violence, and there should be no hate speech. And then the question of the meaning of hate speech is something that people grapple with from time to time. There's a US Supreme Court case, which is almost a paradigm example of hate speech, where the people who are carrying out the so-called hate speech in the European context or in the inter-American context would have lost their case, but in the US Supreme Court won their case. It's a case around the protests outside a church when the burials were taking place of soldiers. It's quite a famous case. So hate speech, again, depends on social mores, the context. The Article 19 pyramid, Article 19 is a kind of a peer organization similar to us. We work with them quite often. They produce very interesting reports on these issues. And their website is well worth checking out. But this is their hate speech pyramid, where you go all the way up to genocide, which is entirely which is entirely kind of unlawful universally. But at the bottom of the pyramid, you do have contentious areas where it's really a question of interpretation and the approach of judges and cultural mores and so on. So on the next slide, we can look very briefly at the case of Osama Hajjaj. He's one of two brothers. He's been charged under the Penal Code and under the Cyber Crimes Act. Very important for cartoonists, the way in which these cyber crimes acts have proliferated across various regions. We'll look at that in a moment, but that's a case just to fake news and misinformation. Again, it's a threat to cartoonists, primarily because you're dealing with very vague, very overbroad laws about whether or not, in certain, we see this in jurisdictions around the world. Legislation is introduced, it's vague, it's amorphous, it's difficult to pin down, and people are being charged with crimes under it on the basis of, for example, fake news. So it's something to be conscious of when engaging in that, but open to challenge, and certainly something that lawyers should quite strongly across various specific countries and states. There is the Berne Convention from 1951, which gives a kind of a broad overview of how states should deal with copyright issues in the context of their work, both in terms of challenging infringement of copyright and being accused of infringement of copyright. Just in terms of using the work of others, there are certain well-developed standards in certain jurisdictions, such as something is in the public domain, it's fair use, or de minimis. In other words, it's a very, very tiny part of your cartoon, and to the extent that it's really not something that should really trouble the person who's alleging that their copyright has been infringed. So just be conscious when it comes to copyright. It's a difficult area. You're best receiving legal advice from someone who's expert in the area, in your specific jurisdiction. Cybercrime, as I say, a proliferation across various regions where the legislation, the provisions of the legislation are almost identical in different countries. And because it's essentially another playbook that's being introduced by governments to suppress speech. And you have the you have challenges in regional and international courts in Africa, for example, which have found provisions of cybercrime laws to be overbroad, to be vague, not to be consistent with the standards one would expect from a piece of legislation where you can foresee what the legal harm is and you can act accordingly to avoid breaking the law. I mean, that's one of the standards that are one of the approaches that you take. But cybercrime laws, if they're coming into your country, we're currently involved in a case in Pakistan involving the PECA, the cybercrime legislation that was introduced a number of years ago following a lot of controversy around the bill. And then the types of, or examples of cybercrime and how they might apply in the context of cartoonists. So then at the final slide relates to, you know, good journalism, responsible journalism, as the European Court has referenced. We don't really like that phrase. I think it's a dangerous phrase if you get into kind of measuring how journalism should be done. One of the things the European Court always says is that newspapers should be allowed to conduct or carry out their journalism according to how they see fit, because they're the experts. But it's important, I think, to be conscious of certain standards. So that's an overview. I hope that was helpful.
It was really, really interesting. So I see that Paresh has put a question in the chat. In India, things are getting more and more complicated and worsening all the time, and he was asking how they could be supported.
I can just mention in relation to that there are, we've worked with organizations in India who are essentially media defense hubs who can represent cartoonists and support cartoonists through funding from various organizations, including potentially us. So if there are any issues around that, you can certainly get in touch with us and we can direct you to some of our partner organizations or lawyers that we know or work with in India. We'd be happy to do that.
I see Terry made a few comments as well. Cybercrime, fake news and vague order reaching laws, few instruments worse than Bangladesh Digital Security Act, which is the law under which Kishore, yes, is being prosecuted.
Yeah, I mean, these cases, Kishore obviously has legal representation, and there's a lot of attention on his case internationally. You're really dependent on the approach of the judges at the domestic courts in a lot of cases. The one thing I would say in relation to the Asian context and the MENA region context, and I did mention that the African Commission does apply in the North African context, but while there are no regional courts, it is important to remember that you can access UN mechanisms and UN bodies. So you do have the Human Rights Committee. Okay, now the effectiveness or otherwise of these bodies is open to debate, but in my view, oftentimes when something is kind of difficult to you know, you're not necessarily going to go to a court and get a judgment that's going to be enforced and you're going to have a meaningful result. At the same time, every little bit helps, and oftentimes in cases like this, the Bangladesh situation, for example, if you're dealing with a judge who's not listening to international legal standards arguments that are being presented in a way that says, well, you know, the prosecution of this individual is contrary to law. In fact, the content of the Digital Security Act is contrary to law. You can potentially look to, for example, in the context of Kishore, you can potentially look to the UN Working Group on Arbitrary Detention if he's being detained for his work. That's a very active body in relation to the detention of journalists, citizen journalists, bloggers, human rights defenders. Now, how effective it is another kind of question, but it does form one part of a kind of general mosaic of advocacy. You know, you do have probably a positive result from the UN Working Group on Arbitrary Detention. We take cases all the time to the working group. They're very helpful, very good, very open to ensuring that, you know, international legal standards are applied. So there are outlets outside of the state if you're faced with a judge who's perhaps biased or, you know, not interested in hearing international legal standards arguments. that avenue is available. But as I say, we're always happy to kind of have a one-on-one if issues arise in that context. There's also the option of attacking the legislation itself. So, for example, the Digital Securities Act may contain provisions that are simply not compliant with international law. That's something, again, that we've done in Kenya, in Nigeria, in other jurisdictions, where we say, well, you know, it doesn't meet the three-part test. It lacks the quality of law. We don't really get into legitimate aim, because, you know, that's a kind of a subjective question oftentimes, that the government can simply say, we're trying to do this. We're trying to prevent ethnic strife. We're trying to prevent people being defamed on a constant basis. But in terms of proportionality and necessary in a democratic society, again, you can challenge those cybercrimes laws, especially the fake news, the misinformation laws, which are really, they lack specificity, and they can be abused. And you see that happening in the Kishore context.
Yeah, and there is a lot of lobby, I think, to change the law. I think in Bangladesh, following actually the case of Kishore and his colleagues who were arrested at the same time in 2020. Sorry. And I had maybe a question. I was interested, maybe if I understood well. So, how often people use, for example, you said there is no court or maybe no specific mechanism at the regional level in Asia or in the Middle East, but I heard you were saying that lawyers use arguments or take example from other regions. That's right. So how
That's
often
correct.
does that happen? Wow, it's a broad question, but
yeah. Well, it depends on the court that you're before. So, for example, in the context of Singapore, for example, where you have defamation cases, there's well-developed case law in relation to that, and the judges are very familiar with common law case law, but are kind of reluctant to listen to general international legal standards. But in other jurisdictions, you will, for example, well, we do intervene as what they call amicus curiae, friends of the court, or third-party interveners, where we will present those international standards to a domestic court. We did that in the context of an internet shutdown in, I think Indonesia, where the internet shutdowns were happening all the time. And that was a successful case where international standards were relied on. But we made the case that, look, you have courts from all over the world which are applying these standards in order to provide protection. They're well established. You can find them in treaties and in conventions. So if the domestic courts are willing to take on those arguments, that's fantastic. But sometimes they're not. And if they're not, the question then becomes, well, where do you go? So for example, in the context of Vietnam, we represent people all the time at the UN Working Group on Arbitrary Detention, where we make precisely these international legal arguments. But then when you get the decision from the UN Working Group, these guys are still in detention. But there are, different cases have resulted in different aspects of different results. So, one person was essentially forcibly exiled, but at least is not in detention in Vietnam. Another person was released. We're not sure if it's connected. There was some pressure when the Vietnam and the EU were negotiating a trade deal. So there was that too. So there's a range of, ways, but we see it as just one part of a jigsaw where litigation can, provide. It can also provide, you have on the record the factual matrix, if you like, of what happened in a particular instance, in a particular case. That's on the record. That can be used by advocates or by people who are engaged in advocacy and so on. So it can be helpful and it can be useful. But I would say there's a huge community where, this is a constant kind of fight where journalists and media houses are being, subject to legal threats and legal pressure. It doesn't stop. In fact, it just keeps getting, I say worse and worse because you're seeing these cases coming out more and more. But the international legal standards are providing this kind of this mantra that you can't do certain things, and in some countries, as a consequence, the legislation has changed. The judges are kind of sensitized to these arguments, and they start appreciating them, and they start introducing them and relying on them. And once that happens, the floodgates open. But I think it's important, if these cases are going through the domestic courts, to get to the apex courts, the Supreme Court, the Constitutional Court, where the judges will give a, there's an element of embarrassment involved too, where judges are reluctant to be seen not to be up to date with the latest, considerations of their peers in other jurisdictions, which would have higher profiles, for example. So there's that too, the embarrassment factor. But there's a range of techniques, legal techniques, that you can use to provide protection in various ways. But having said that, sometimes when those legal techniques are used, the result is not necessarily the outcome is not necessarily changing very much. A cartoon is considered a cultural and artistic expression. I mean, it depends on the cartoon, but I would think in broad terms, for people who are serious cartoonists, I would say yes, and that would kind of underpin your freedom of expression arguments, that you're engaged in a cultural and artistic expression, which contributes to, a democratic society, because oftentimes the starting point for the argumentation in a freedom of expression case, and something that is constantly repeated by, I keep going back to the European Court, but it is the gold standard, the European Court, when it comes to this, and the inter-American courts as well. But they do say that freedom of expression underpins a democratic society, and then you move from there, if you like. So in the case I showed you earlier around Jerry Falwell and Hustler magazine and Larry Flint, the court did talk about the importance of cultural and artistic expression in the kind of the fabric of the nation. So yes, I think the answer to that is that, almost certainly, if you're a professional cartoonist.
Because you see today, the social nets are full of non-professional cartoonists, okay, or self-declared cartoonists. So is there a legal difference between someone who is working as a cartoonist as a profession and publishing on the let's say, a known media, or any individual who puts on Instagram or where he just wants anything he wants to do? Is there a difference if you are sued in justice, for example?
Well, it depends on where you're sued, but under international law, I think it's now well established that journalists and what they call citizen journalists, for example, to make that distinction, are the same. And we do make this argument a lot, that, for example, some states require accreditation for a journalist, or a cartoonist is a member of a particular guild. And that would be the argument. If someone isn't a member of a guild, that might be the argument to say, well, they're not a cartoonist, so they shouldn't be given that protection. And we would argue to the contrary, and I think international law says that if you're somebody who's on Instagram putting up political cartoons, if you're making a statement in the public interest on a matter of interest, if you're a, say, citizen cartoonist, in the same way citizen journalists get on Facebook and talk about public interest matters, you're entitled to the same level of protection. And remember, it's a heightened level of protection that you're entitled to under international law. So a citizen is entitled to freedom of expression, but a journalist or a cartoonist is entitled to a heightened level. Now, what that looks like depends on the case, the specific case, but it's an argument to be made that not only should you not be interfering, but you should in fact be protecting the ability of journalists and cartoonists to go about their business, including, let's call them, citizen cartoonists, in the same way they're called citizen journalists. So no, there's no distinction. I would be very I would be very quick to push back against an effort to say there is a distinction between those two classes of cartoonists, if they are indeed distinct.
I had another point, is that today, actually, in the spirit of the time, any cartoon you do can be considered or attacked as a defamation. You are under threat all the time.
Yes, it's true. I mean, it because of the polarization, you do see everyone on one side reacting to what's done on the other side. Well, I mean, this is where you rely on strong legal standards and legal principles, because if you're going before a court, they'll approach the case in that context. The case may not even get to that point. But I think the issue around polarization is now you're seeing, I mean, the key point here is that you're engaged in public interest commentary and public interest engagement. So the let's call it the Overton window of the public interest is shifting all the time. It's expanding to such a degree that it's becoming very difficult for courts to, in terms of defamation claim. I mean, defamation is a specific type of legal challenge. But if you're commenting on the public interest and you're commenting on a public figure and you have that heightened protection as a journalist, you know, unless you're in London, unfortunately, which is really the epicenter of all of these big libel cases, because that's where they see generous damages being awarded, and unfortunately, unhelpful legal standards being developed by the domestic courts, and different ways of bringing these kind of defamation type claims, because they can be data protection claims. You should, if you're outside, you should be able to rely on international legal standards. But defamation is a specific, as I say, it's a specific issue which requires legal advice in a specific context, in a particular state, where a judge, the court system might have a particular approach, and the legislation might deal with it in a specific way. But I think the starting point in terms of international law is you have heightened protection, and you're entitled to comment on public figures. And again, I go back to that Jerry Falwell parody and the way the court approached that and the things it said. It's quite a rich, you know, rich in content in terms of how it addressed the question of defamation and public figures and public interest.
Okay, it's also a question of tradition.
Yes.
Because in the UK, for example, you have some of the most extreme cartoonists ever since the 19th century, and Gerald Scarfe and Ralph Steadman. They were used to go so far that they somehow have instituted a sort of UK tradition of cartoon that gives different limits, okay? Or like Charlie Hebdo, for example, a satirical magazine in France, okay? Who is so many times misunderstood in other democratic countries. I'm not talking about the non-democratic ones, okay? There's a big misunderstanding between France and America on this point, for example. Don't you think?
No, I agree. I mean, you look at Steve Bell in The Guardian, for example, is also pushing boundaries in back when the Iraq war was, or when the invasion of Iraq took place in 2003. So it is a question of tradition. It's a question of evolution. It's a question of societal standards. I mean, there's lots of factors at play here. But I think in broad terms, you return to these first principles around international legal standards with an eye on the specific issues that arise in the country context, I think.
We are a bit over the time. Maybe I saw that Terry had his hand raised, so maybe if Padre agrees, maybe we can take a last one before we close out.
Yeah, just very briefly, the UN special rapporteurs were mentioned earlier on. Up until recently anyway, the rapporteur for cultural rights has been perfectly happy to accept cartoonists as part of that. So as far as the distinction between, is it journalism, is it art, is it art, what have you, the special rapporteurs have been perfectly satisfied to accept either argument. You can approach from the journalism point of view, or you can approach from the artistic expression point of view. This is Karima Boonan's last week, of course. She's moving on. I haven't had an exchange with her successor yet, but I assume the new rapporteur will have the same kind of attitude going forward. And as far as the distinction between the professional and amateur is concerned, again, depending on what part of the world we're talking about, but particularly in these parts of the world, Asia and the Middle East, in certain countries, the only cartoonists that there are, if you like, social media based cartoonists, because they cannot be and are not in the press. I put a link in the chat to Kashmir as an example, where essentially all the cartoonists have been eradicated from the news media. And the case that was mentioned earlier, Kishore, he's in trouble because of cartoons on Facebook. Zunar, one of the most high-profile cases of all recent years, was a self-starter. We didn't have any established relationship with any particular news outlet, So increasingly going forward, it's going to be a distinction without a difference. I think the cartoonists we're going to be talking about will, for the most part, get into trouble because of the opinions that they are expressing under their own name and under their own banner, whatever that may be, as opposed to a press outlet or a news media organisation.